Hi, welcome to Understanding Problems and Providing Solutions with.
Hi, this is John Maxwell with the Maxwell Group at Keller Realty, Central Delaware.
And I'm Samantha Maxwell with the Maxwell Group.
And my name is Adam Gerber. I'm a partner at Wolfe and Associates.
So really quickly, I just want to discuss equal housing opportunity, marketing, and advertising. We're pledged to the letter and spirit of the U.S. policy for the achievement of equal housing opportunity throughout the nation. We encourage and support fair housing for all and business strategies in which there are no barriers to obtaining housing because of race, color, religion, sex, handicap, familial status, or national origin. We are dedicated to assisting real estate clients in reaching and serving the needs of all. So what we'll cover today: what is probate? Tips and tricks on probate, common terminology, understanding the probate process, and how to avoid probate.
So let's start here with what is probate. Probate is a legal process for the transfer of assets, such as houses, cars, stocks, bonds, boats, etc., from a deceased person's name to his or her estate so that they can be sold or distributed to the heirs. It's basically the method or the process by which the Register of Wills Office or Probate Office oversees the administration of a person's will. If they don't have a will, then their intestate estate.
Yeah.
All right, so generally the process of probate takes place in the county of the decedent's residence. So in other words, wherever the decedent died, the decedent being the person who was deceased. Probate then, like I said, is the process by which the Register of Wills oversees the settlement or administration of the estate. Probate validates the terms of the will, if there is a will. In other words, the Register of Wills Office or Probate Office will review the will and make sure that the terms of the will are valid and that they are carried out by the executor of the will. The probate process, part of that process, is for the executor to pay legitimate creditors and then distribute the remaining assets of the estate to the beneficiaries named in the will. The probate is a matter of public record. In other words, the will is recorded with the probate office and becomes a matter of public record, as well as the other filings related to the will, and then something called an inventory that shows all the assets in the estate, and then the ultimate accounting showing the assets of the estate, the debts paid, fees paid, things like that. So all that becomes a matter of public record.
Correct. So we want to talk about generational wealth as well. Generational wealth are assets that are passed on by one generation to the next. For example, somebody may have passed you on something in the will. Business, land, cars, and specifically real estate. Typically, real estate is the most argued asset.
That is true.
Who do you know that needs help with trust or probate? That is something that we just want to make sure you've received this. We want other people to receive this as well. So please share the knowledge.
All right. The problem is that we live in an industrial society and value dependent. So we didn't grow up with certain conflict resolution communication skills. At least usually most of us didn't. I know I didn't. Only about 30% of Americans do estate planning, unfortunately. And the failure rate is approximately 70%. About 3% of failures are due to probate and improper tax planning. And 97%, so the vast majority, are due to improper receiving of assets, misspending, theft, etc. 70% of trust litigation is between siblings regarding real estate. So that really is, as the prior slide said, one of the most contested assets in someone's estate. And usually because it's the primary or the biggest asset in the estate.
The biggest asset, the most controversial, and it can just get messy. And that's why we want to help prevent problems in probate. So understanding KW real estate planning, according to the National Bar Association, 40% of U.S. citizens die annually. It's a horrible statistic, but it is something that we just have to know. 71.6% of us die without an updated will. That causes conflict in the family. And that causes problems instead of generational wealth. So more than ever, these individuals need the expert care and compassion of real estate professionals specializing in probate and attorneys specializing in probate as well.
All right, so we'd like to address now the difference between community property and non-community property estates, because this has an impact on how the estate is administered. Now, there are only a few states currently that still are community property states, which I believe will go over the next slide or the next couple slides, but I just wanted to briefly run through the differences between those two terms. So community property states. If you're in a community property state, you can't have an individual trust if you're married. In other words, the property is held jointly by the spouses and can't be divided up in the same way it could in a non-community property estate. It's also important to note, if you're upon your passing in a community property estate, you're required to leave 50% of your estate to your spouse. You can usually pass on, half, the other half to whomever you wish. Again, in a community property estate, some of them allow you to add a right of survivorship provision, which allows for the deceased portion to pass through to another surviving spouse, to the surviving spouse while avoiding probate. Other community property states do require probate. Now, Delaware is not a community property state, but
Correct.
That's how the community property states work. So then in all the other states, the non-community property or marital states, property obtained during marriage is owned by both the members of the couple and divided between the parties in a divorce, annulment, or death. So there may be some differences, for example, about how much ownership each party has, depending on their contribution. So especially in the incident of a divorce, that becomes a matter of debate. So there are non-community property states that follow equitable distribution rules. Most following these equitable distribution rules classify jointly owned property as marital property. So, that all has to do with the distribution of assets if there's a dispute as to how they should be distributed.
Understand. And again, knowing your state status is very important. Delaware is a non-community property state, as he had already mentioned. However, there are still 9 U.S. states that are community property states. So if you do have somebody going through probate in these states, it may vary, it may be different. And if you have different properties in maybe one of those states as well as Delaware, there could be a couple different issues that you may run into.
That's exactly what I was just going to mention. If, for example, the person lived in another state and acquired property in that state, you just have to watch out and make sure that you keep track of exactly when and where the property was acquired, just to make sure that you're covering all the bases.
Yes.
All right, let's move on to some common terminology in probate. So you have the decedent, which I kind of mentioned before. That is the deceased person. We refer to them as the decedent. There's the personal representative or the executor. Sometimes we use the feminine and masculine terms, executrix, but the personal representative or executor is the same person. I mean, it's a term for the same person. That is the person who is in charge of filing the will with the Register of Wills office and then carrying out the provisions of the will under the supervision, again, of the probate office. Right? So they're the one responsible for that or in charge of that. Now, we can also refer to them as the administrator. So there is a distinction in Delaware and I'm sure other states where you have someone who is the executor under the will, but if the person didn't have a will, then we use what we call the intestacy laws, which are essentially just default laws that say that property in essence goes to next of kin. So sometimes we would refer to them maybe as the administrator, or those terms are often used interchangeably, so you don't want to get too caught up in those, but I did want to point out that there's a distinction between when someone has a will and when they don't have a will. So. All right, so a couple other things related to wills. There's a codicil and an affidavit. So a codicil is really just it's an amendment to a will. That's really what a codicil is. An affidavit is just really refers to any type of sworn statement. So I already mentioned the testate versus intestate. So again, testate is when you have a last will and testament. That's where that comes from. Intestate means that there is no last will and testament. That relates, again, as I mentioned, to how you would treat those filings slightly differently. If somebody doesn't have a will, then that would be orders of administration or letters of administration as opposed to letters testamentary. Basically, whenever you think of testamentary, it's last will and testament. That's kind of how to keep it straight. And then beneficiary versus heir, there could also be a difference in those terms depending on whether or not someone had a will or not, but I don't get too caught up in those. Frankly, for better or worse, those terms are often used interchangeably.
Understood. So understanding the probate process, there is a beautiful timeline that you'll be provided. Just reach out, and if you've received this, then you're most likely going to have us reach out again, or you can reach out to us, and I can give you a full probate timeline. And it's very much so what Adam has discussed already. However, it's in a beautiful format, and it really gives you the timetable, because the timetable is very important when it comes to the probate process.
It is, and if you give me a minute, I can kind of give you an idea of the timeline, at least in Delaware.
Of course.
So in Delaware, and again, I'm licensed practice just in Delaware, so I'll speak to what I know in Delaware, but the timeline is this. When someone dies, theoretically, they're supposed to go to the probate office within 10 days. No. that's a flexible deadline, let's say, but soon after the person's death, you're supposed to go to the Register of Wills office, the probate office, and file the will, and then file some other paperwork to open up the estate. Once the estate's open, 90 days after that, you file an inventory showing, and by you, I guess I mean the executor, the person in charge, right? The executor files an inventory showing all the assets that the person owned in their sole name at their time of death. That's important, we'll come back to that later. But then you have to leave the estate open for at least 8 months from date of death. That's for creditors to make claims against the estate. In other words, anyone that was owed money by the decedent can make a claim against the estate. They file that claim, and then the executor can decide whether or not to pay it or if it's legitimate or not. But anyway, the estate has to be left over for open for at least 8 months from date of death. Once that time period is passed, then the executor can file a final accounting showing all the debts of the estate that were paid, and all the other expenses paid, and they file that with the probate office, at which point the probate office reviews and approves that, and then once it's approved, the estate can be closed out and the final funds distributed out to the beneficiaries.
Okay, yeah, that really gives you a timeline, and unfortunately, 10 days sounds really quick. So,
It is very quick, yeah.
Unfortunately, that's something that, again, probate can be put off because you are dealing with a lot, and a lot of people don't necessarily think of as that's one of their first steps. However, as quickly as you can, especially if there's any sort of real estate to be divided, that is something that you should start as quickly as possible, so that the rest of the process can begin as well.
Exactly.
All right, so just a couple of things with triggering events, real property process and the personal property process of probate.
Sure. So there's a triggering event here. Let's say at the death of, if someone's death, you determine if the decedent died testate or intestate, like we talked about, whether they have a will or not, because that does make a difference. If there's no will, then the law, this default law called the intestacy law, that governs and essentially says that the next of kin of the individual would inherit. But if you have a will, then in that will you can leave your assets to whomever you want, right? So obviously that makes a big difference. You have to review the will and see exactly what it says if there is a will. Again, like we talked about, you petition the court to open the probate. Again, it's supposed to be done in 10 days. That's a little bit flexible, but that is tough because usually people are still grieving, and that's tough to have to start thinking about all this paperwork right away. Again, then you obtain the letters testamentary. Those notices go out to creditors. You pay state and federal taxes. So yes, you do. Some people have questions about this. You do still need to file taxes for the individual for the year, that in which they were alive, as you have to file those final taxes. Maybe file estate taxes, but that's only if there's a certain amount of income. You can talk to a tax professional about that. And then again, once that accounting is filed and approved, then you can make some distributions. You could make some preliminary distributions before that. You want to be a little careful about that. You want to make sure you have enough in there to pay creditors, but just so you know, you could make some initial distributions, like reimbursing people for, like heirs for amounts paid out of pocket, things like that, but you've got to be mindful of potential creditors. And then again, you have the final discharge order and the final distribution of all the assets, like I was kind of talking about. Now, the real property process, would you like me to talk about that a little bit? Feel free to jump in, but.
Oh yeah, I can definitely head that one off. The real property process is typically when there is a real estate property involved in the transaction and in the will, and then realtors get involved. We provide a time of death appraisal. It's very important so that they understand what value the home has at the time of death. Now, if you have prolonged probate and it's 8 months later, that value is going to be different than the time of death value typically. The market does have different fluctuations, so we want to make sure that we know the time of death and we can provide that appraisal based upon that date and time. We do need to review it with the personal representative, and then walk the property and determine the listing timeline. So John Maxwell is our listing specialist. He will go out and he'll be able to walk the property with you. Making necessary repairs are always important to listing to get the most value out of your property. However, there are options on not doing any repairs and having it paid out of the proceeds, and just listing it as it currently stands, which is called as is. providing necessary documentation to title, to list, sell, and close on the home. So that's when we get Adam involved, and Delaware is an attorney state, and we make sure that all our T's are crossed, all our I's are dotted, and you are comfortable in what the process is. You are communicated about the process, and everything is done to the letter of the law.
Absolutely.
Yeah.
I would like to jump in here and just stress how important it is to have a good real estate professional who understands probate and understands how real estate is handled, especially in Delaware. Again, can't speak to other states, but in Delaware, real estate can be confusing when someone dies, because even if there is a will, depending on the wording of the will, usually the heirs become the owners of the property automatically. So in other states I've dealt with, here and there, sometimes the executor is the person who's going to be signing the listing agreement, for example, and signing the deed, the closing documents. In Delaware, that's generally not the case. So you do want to be very careful and have a good real estate professional looking at this so that they know exactly who should be signing the listing agreement. So if you have 4 heirs, for example, and then 1 executor, well, probably all 4 of those heirs are going to need to sign off on all those documents. So that's a really key piece here in this process. Too many times I've seen, us get very close to the closing date and then we realize we don't have the proper parties that have signed off. So that can really delay things. And with a good, real estate professional, you can get ahead of all that and just make sure you have the proper parties signing off from the beginning.
Most definitely, and unfortunately, sometimes people are misconstrued with the executor, personal representative, has the sole power, and that really depends upon the will, correct?
It does, and that's a good point. So, and only if the will specifically directs the executor to sell the property will the executor be the one signing off. So that's the only scenario in which the executor will be signing off. Otherwise, it'll be all the beneficiaries under the will. So that's a good point. So, and that's where we run into those problems sometimes.
Yes.
Because I do believe in some other states, the executor is the one signing off, but in Delaware, it's the heirs that usually sign off unless we have that very specific language directing, instructing the executor to sell.
Exactly. Yeah, so this is another reason why we're talking about generational wealth and being able to leave your wealth to the person that you have determined that you want to, and to also prevent any in-family squabbling and any sort of tension that could occur when these types of situations arise. So that brings us to, how do we avoid this? So how can probate be avoided?
Sure, of course. Well, so I'll begin with saying that I think there's a common misconception that if you have a will, you avoid probate. So that's not the case, as we've been talking about before. The probate process is actually the process of the probate office overseeing the administration of a will. So if you have a will, that's exactly what you have to file with the probate office. And then you have to report all of your assets to the probate office. And actually in Delaware, it varies slightly by county, but especially in Newcastle County, there is a 2% fee on all of your probate assets. So you have to be careful about that because there are just a lot of fees and delays involved in the probate process. So if you just have a will, your assets will have to go through probate. But there are ways to avoid assets having to go through probate. So that involves 2 main things. First of all, if you name a beneficiary of an asset, this usually applies to accounts like a retirement account or investment account. If you name a beneficiary on an account, that asset will then go directly to the individual at your death and will not have to go through probate. So it goes directly to the individual, won't have to go through probate, so it's not caught up in that whole probate process. So that's one main way, and frankly, that's a free method of estate planning. At least that's how I think of it, in that when you're naming a beneficiary, you are planning your estate to avoid probate. So for those assets, they will avoid probate. Now, unfortunately, there's not a way to set up a beneficiary with your house and with tangible personal items like personal property in the same way. You can't name a beneficiary directly generally. So for those assets, you would have to set up a trust. In this case, it could be a revocable living trust. Revocable meaning that you retain in the trust document the right to revoke that trust, to amend it up to the point of even revoking it. And it would be a living trust, meaning that you set it up during your lifetime. So if you set up a trust like that and you transfer title to your assets into that trust, Those assets then are no longer in your personal name and don't have to be reported to probate. So they don't have to go through that whole supervision process of probate. They'll go directly to the beneficiaries. Now, there are lots of other advantages of a trust that we could get into, but right now we're just focusing on how to avoid probate. So for, like I said, accounts primarily, you can avoid probate by naming a beneficiary. So that's something everybody should look into. You should do with your financial advisor or whoever. But then for other assets like your house and your tangible personal property, you want to set up a revocable living trust to transfer the title of those assets into the name of the trust. That keeps them out of probate.
Perfect.
So,
and another thing that people try to do is to provide the property and transfer the property to the heirs or beneficiaries as gifts while
yes.
still alive.
Mm-hmm.
However, this does change your step up in cost basis.
Yes.
So unfortunately, that will change your capital gains tax that you owe. So a trust will help alleviate that step up in cost basis to be able to provide you with the full benefit of equity to your name. And that way, essentially, a step up in cost basis is if a person passes and they have already given the property to their heir or whoever they wanted to add on to the property, you have to pay capital gains from the day that they received the property. So the day that they purchased the property for $100,000, now the value is $500,000. That's $400,000 that you have to pay capital gains upon. Now, if you had left it in a trust, and then you were able to have that $500,000 step up in cost basis, allowing you to not have to pay that additional capital gains on all of that equity that has been increased over the years.
Exactly.
Because that's why we buy real estate, right? It is typically an appreciating asset. And it is something that over time can really benefit you and help provide generational wealth. But we just have to make sure that we're passing it on properly so that we can access that generational wealth.
Yeah, that stepped up basis is really a huge advantage. And I get this question all the time from clients, right? They're concerned about their assets, their house especially, and they want to give it to their kids now. But yes, there are a couple of big disadvantages, the main one being that potential loss of capital gains. Or excuse me, the disadvantage is that they would incur capital gains. So this loss of stepped up basis is really what we're talking about. So that was a good explanation. That's exactly right. Essentially that capital gain just kind of disappears, which is great if you leave the property to your heirs at your death. So that's really nice.
That's not to say that somebody can't live in the property and take care of the property, but your name cannot be on the property unless you want to incur those additional capital gains taxes.
And another concern I have there is if you give your house, for example, to a child, well, if the child got sued for something, got in an accident, got sued, well, then technically that asset is in their name, and the creditor could come and take what was your house, to collect on a judgment against your child. So there are a couple concerns with giving property to your child during your lifetime.
Correct. So we just want to transfer generational wealth as seamlessly as we possibly can.
Exactly.
So there's a couple different special types of probate. Do you want to give us a...
Yeah, so there are some different types of probate generally. A conservatorship, court proceeding where a judge appoints a responsible person, that's called a conservator, to care for another adult who can't care for him or herself. There's a guardianship. So guardianship is similar to conservatorship, but it's when a probate court appoints someone to be the guardian over another individual, a minor person who's incapacitated. So now we use slightly different terminology in Delaware, but generally, like I said, when I'm talking about probate, I'm referring to our Register of Wills office. There are different terms for different courts and different processes in other states. But just generally, this will help give you a good kind of idea of what these various things are. And then the living trust, in fact, that's what we've been talking about. They are also very valuable or can be very valuable during your lifetime. So just keeping in mind that there are other advantages and ways to use trust as well. If someone were to become incapacitated, or especially, this is a little off topic, but especially if you have an individual with special needs or something, you really want to be thinking about trust planning.
Yes, understood. And we'll get further into trust when we do our trust video for them,
Exactly.
so they can also benefit on learning a little bit more about trust.
Yep.
Yeah. So how do we help as KW planners, John?
So as KW planners, we are here for all of your probate needs. Whether it be your legal services, whether you need clean out, landscaping, listing, that's what I do. Be more than happy to come and look at the house, help sell the house, go over the options too if you decide, even if you've decided to keep the home.
Definitely.
We have those options that we can help you with as well.
I think it's always good to be able to have all of your options out on the table. To be able to know, and knowledge is such a powerful thing, to be able to know what each option will provide you, and then you can determine what works best for you. So we're not here to make any decisions for you, none of us. We're here to just provide you the process and a seamless way to be able to go from filing probate to finishing up with probate, and also a seamless way to prevent probate as well. So thank you so much for joining us today. Thank you for listening to us. If you have any additional questions, we are here for you. Just contact us and I'll provide that contact information as well. Adam, thank you so much for all of your wonderful information. We truly appreciate you, and I know that you have helped so many people and you will continue to help so many people in Delaware. So definitely, if you need any sort of anything when it comes to an attorney, Adam's the man, especially probate, but you do have other specialties that you do have. So his information will also be provided. So you can contact us at any time. So thank you so much for joining in.
Thank you.